those who have come here physically, for making the trouble to come down to join us for this event. And thank you to all of those attending virtually as well, for sparing some time this Friday evening to join us for this event. Today, we will be having a fireside chat discussing trends and developments in the SICC and third-party funding. We'll be discussing the SICC rules, the new rules that have come out, some recent SICC cases, and then we'll also be discussing changes to the legislation that allows third-party funding to happen in SICC cases as well. Yeah. Without further ado, I will introduce the speakers this evening. First, we have Mr. Nish Shetty, who is partner at Clifford and head of international arbitration and dispute resolution for APAC. Nish is recognized as one of the leading arbitration practitioners in Asia and has advised on complex cross-jurisdictional disputes for 27 years, including arbitrations in Europe and Asia. Nish acted in one of the earliest cases to come before the SICC, Macquarie Bank Limited and Graceland Industry Private Limited in 2018, in which CC acted for the successful claimant. Next to me, I have Mr. Lawrence Wong, Senior Director, Business Development, SICC. In this capacity, Lawrence develops awareness and engagement of the SICC with various stakeholders with the aim of encouraging more of them to see that international dispute resolution can be both cost and time effective, and that the SICC is strategically located in the Indo-Pacific to provide this as a trusted, neutral platform. Before joining the SICC, Lawrence's background was mainly in financial services, and he has held key positions in multinationals within the region. This is a fully virtual event. We have some attendees physically and virtually, and we also have some speakers attending virtually as well. On the screen, you should be seeing now Mr. Dakis Hakan, King's Counsel. Dakis is a SICC specializing in chancery litigation, with an emphasis on contentious trust cases, usually of a complex commercial and international nature. Dakis has appeared as leading counsel in courts in England, the Cayman Islands, the British Virgin Islands, Gibraltar and Bermuda, and has appeared before the UK Privy Council. Dakis is also the co-founder of Hereford Litigation, a privately owned litigation funder, which looks at global opportunities. Also on the screen is Mr. Ben Mays, a partner at Hereford Litigation. Ben's remit at Hereford includes the funding of high-value, complex, cross-border commercial litigation and insolvency cases. Ben has 24 years experience as a litigation and insolvency lawyer and has also been a trusted advisor to investors, corporates, institutions, insolvency and other professionals for over 20 years. For myself, I'm Victor Yao. I'm an associate at Kavanagh Law, and I'm the moderator for today's event. Right, that's enough by way of introductions, and I'll now pass the time over to Lawrence, who will discuss the SICC Rules 2021. Over to you, Lawrence.
Thanks, Victor. And well, welcome to everyone, both over here on the viewing gallery of the Supreme Court of Singapore. For those virtually, you can't actually enjoy the wonderful view that those who are in person are enjoying. At least I hope you're enjoying it at the same time. Yes, interesting concept of fireside chat in the sense that the fireplace is in two places, both in London as well as in Singapore at this point in time. But can we just sort of move forward onto this? And I'd just like to start off with what the SICC Rules 2021 is. I've sort of labeled a game changer in international dispute resolution. If you think about it, the SICC was launched back in 2015. We've had sort of 7 years to look at how we've managed matters that's come before the court, what are the experiences of counsel working with the judges in our case management conferences, and sort of looked at how the rules of court in the SICC versus the High Court were very different. And they were, in a sense, very, very different. That as we started looking at it, we felt it was time to sort of spin off onto its own standalone rules. So hence, we launched the SICC Rules 2021 in April of this year, basing on 4 general principles. I can see that. The first one is the most important aspect: expeditious and efficient administration of justice, according to international commercial law. The key consideration has always been time and cost for counsel, for clients, especially, whether you're the plaintiff or the defendants. So it was how we can move matters through as quickly and effectively as possible. But based on the second procedural, the general principle that you see, that of procedural flexibility. As we built the rules of court for the SICC, it has always been taking aim or being cognizant of party autonomy, being cognizant of effectively international best practices in dispute resolution that counsel is experiencing in other forms of fora. So we built in the procedural flexibility. We've made sure that the processes are fair, impartial, and practical. Again, without very rigid rules in that sense, unlike in a normal common law court, I would say. And also finally, procedures are compatible with, as well as responsive to the needs and realities of international commerce. So always the point is international best practices with consideration for time and cost, right? We've refined our jurisdictional rules. So once you have a jurisdiction clause that says SICC, the presumption is that the action is international and commercial. In the past, if you didn't have a specific, notwithstanding the fact that you have written jurisdiction clause that says SICC, you still had to prove or you could be challenged that the matter was either not international or not commercial, but we sort of removed that with our SICC rules 2021. And applications for transfer from General Division of the High Court to the SICC, no consent is required at this point in time. Unlike the previous, when we first started, consent was actually required for that. And we've now extended jurisdiction to consider applications under International Arbitration Act, right? And that is something that has been evolving and something that the SICC has been looking at more and more recently. And the last bullet point that you see down there, there's an expansion again of jurisdiction to the SICC for international and commercial corporate insolvency and restructuring, as well as dissolution proceedings. So we've had Singapore's implementation of IRDA, Insolvency Restructuring and Dissolution Act, and now that's very clearly, we launched it, the rules, and I think Victor will expand more on that later on. Commencement of proceedings, we've brought it all into one, and we've used the term originating summons. For those familiar with the Singapore High Court, you know that, or even with the SICC in the past, you sort of had two gates. One's a writ of summons, the other one's originating summons. But we're now saying it's one, and at the first case management conference, there will be adjudication tracks that parties have to agree with the court on how to move forward. Pleadings would be similar to your previous writ of summons. Your statements would be quite similar to the originating summons. But the third track that we've implemented again is something innovative, especially in common law court, and that was memorials. So submissions only, and then after that, judgment will be handed down based on that. Again, you think about it, overarching theme is always efficiency and effectiveness, time and cost. In terms of case management conferences, the unique part of the SICC, I would feel, number one, they are judge-led. The judges are appointed the moment the case is accepted and on the docket system. And we insist that lead counsel are to attend case management conferences. And even things like case management bundle to be submitted would have to include all the items that you see there: pleadings, case memoranda, list of issues, your proposed case management plan. At the case management conference, the first one, and then judges will move forward with parties. And we found that this was a very effective approach, and that's something that we've actually strengthened with our SICC Rules 2021. We have sort of retained, in a sense, but reinforced the flexible disclosure rules. The default before the court is no general discovery. And again, this is something deviating, in a sense, from the High Court, right? But the court is also, however, the court is empowered to make an order for general discovery if it so finds it expedient or necessary, like especially in matters where fraud is suspected. So with that, the court is able to move away from the default procedure and then order full discovery of that, right? And it's also, court is also empowered to dispense with the disclosure of documents altogether, again, depending on the matter. And that sort of shows the flexibility within the court. Evidence, again, is something that the SICC is known for in terms of uniqueness. So by default, evidence is adduced by way of witness statements. So we've done away with affidavits that we have in the past. So it's more clearer, it's more focused. A statement of truth is required now from the witness. Your affidavits may be required. However, affidavits may be required in certain circumstances, again, depending on the matter, but if not, the default position is witness statements. Now, being a court in Singapore, the Evidence Act of Singapore actually applies, but parties can mutually agree to disapply Singapore Evidence Act and take on a different set of rules. And I think for many practitioners, they're quite familiar with IBA rules on taking of evidence in international arbitration. So parties can mutually agree to adopt those rules instead. And this can be done even at contract stage before a dispute actually arises. Because I think, as you know, most times after a dispute arises, it's quite hard to get mutual agreement on such things. So for the transactional lawyers there, please take note of that. Experts now need to be approved by the court before they can be appointed. And we've made this very clear within SICC rules. And again, the court can look into it and actually get parties to agree for the appointment of single expert witness only, again, to save time, to save costs. Or if it cannot be agreed, then the court could actually directly order the appointment of a particular expert. Trials and hearings, again, we have now stated a single trial bundle is a default. So documents included must be only put in once. Exhibits to witness statements on expert reports are to be cross-referenced. And this one came about, interestingly, in terms of anecdotal past, is that some of the international judges, especially not from a very common law background, basically said, why am I reading the same affidavit in 5 different places from different parties? Okay, where I could actually read it once, actually save time and not have to do it again. And that's why we've looked at it and we said, okay, everybody has agreed on a single trial bundle. And in order to save reading time in that sense, and to actually have it more focused. And also, I guess, in terms of today's ESG type initiatives, we have less trees that we can cut down. Of course, the ideal situation is to go totally paperless, but I think that that's a different aim in the future. Appeals, we've also expedited a time frame for appeals against decisions. The Court of Appeal may also decide on any matter without hearing oral arguments, and that's a prerogative as contained within SICC Rules 2021. And the parties will continue to be able to restrict or limit the right of appeal by agreement. This is something that we've actually made it very clear. Parties can agree, for example, totally to agree out of the right of appeal, or say if there's 5 issues to be heard by the court in the first instance, parties can agree issues 1, 2, and 3, once judgment is rendered, no right of appeal, but 4 and 5 may be appealable. Again, there's a sort of flexibility that we've built within the SICC. But the distinguishing point as opposed to arbitration is that you do have the right of appeal within SICC, unless you contract out of it yourself. We've made it very clear they were ADR friendly in this sense today with the SICC Rules 2021. Parties are required to consider a possibility of alternative dispute resolution, meaning mediation in that sense. And Junie down there will be very happy to hear this, that we're actually helping to push matters across the SIMC on this one, right? And those who not know Junie's from SIMC, please introduce yourself to her after this. You owe me a drink after this, Junie. Yep. And they are to consider the possibility of mediation. And after the first case management conference or any case management conference, if parties say they will go towards it, they are supposed to update the court at the next case management conference. And if one of the parties basically say, Nish didn't seem like he was sincere in attempting mediation, the court will take note of that. And if Nish's party is unsuccessful, the court orders could actually work against the party that was intransigent in attempting mediation. just hypothetically, Nish, obviously, right? Yeah, so, and if parties actually do not wish to attempt, but then the court feels that there is a possibility, the court can actually order mediation, but it's not a default order in that sense, right? As the last bullet point, as I said, is a factor in determining costs for parties against which who were not sincere in attempting mediation. And as we talk about costs, the distinguishing factor again for the SICC is there's no taxation of costs. So costs are set at the discretion of the court itself. I won't read out the words, you can see it on your own, but the two key words is proportionality and reasonableness. So there's no Appendix G for those who are again used to the High Court system of costs. It's reasonable, it's what is proportional, depending on the conduct of the party, the values of the claims, complexity of the subject matter, and so on. So that's a key deviation within the SICC compared to other common law courts. This one's a mouthful, but I don't expect to go through the entire term. But to mention that we have looked at cases, and as you know nowadays, many matters are multi-contract, multi-party situations, which brings up complex cases. And the key ones would be your technology, your infrastructure, and construction type disputes that happen, where you can have 20 parties involved with 75 different matters, different contracts behind it. So we set up what's known as a TIC list to such that we provide additional case management features that can help. We've even introduced voluntary protocols. The first one that you see in red is the simplified adjudication process protocol, where parties can agree that the court will consider the substantive matters. Like, for example, you may have 20 matters. 5 of those matters we heard. The remaining 15, once the substantive issues are dealt with, there's a standard flat rate for damages to be ascertained. So that's something that parties can agree to. The other one is a pre-action protocol that very early on you start having frank and early exchange of information so that we can start laying out the method to move forward on. So these are, I would be unashamed to say that this is something that's been happening in international arbitration, and we sort of just brought it back to say that within the SICC, we can actually consider working within this and making use of different types of schedules, like Scott schedules that you see down there. And we've set aside a separate list of judges that help deal with such matters. In your infrastructure matters, for example, the two of our international judges definitely stand out is Douglas Jones from Australia and also Sir Vivian Ramsey from the United Kingdom that would in most likelihood hear such disputes that come about it. Foreign representation. I'm sure many of you know this, but I'll just mention this, that lawyers who are not registered at Singapore Bar are able to represent parties within the SICC. And in certain cases, in what we call offshore matters, offshore cases where there's no substantial connection with Singapore. This does not include, for example, Singapore subsidiaries of foreign entities dealing with a matter in China with payment in the United Kingdom, for example. So even though there are 2 Singapore registered entities, but if ownership can be traced back, that they are not Singapore companies, then it can be established that there's no substantial connection. Okay? The other one is on questions of foreign law. Again, questions of foreign law in the common law court has been proved as a fact. But what we allow within the SICC is for lawyers who are competent in the aspect of foreign law to actually submit directly to a court. So you avoid the fact that you have to appoint an expert witness to file an affidavit and then be cross-examined in court. The third one is on cross-border corporate insolvency, but that one is with the permission of the court, and again, will not cover aspects of Singapore side of the insolvency. The minimum requirements is very simple: minimum 5 years advocacy experience, no disciplinary action by local bar, past or present, and a fluency in English. And no, we do not conduct English tests to ensure your fluency. Confidentiality, just to round off this one, I think, what's the time? Okay. It is not right to say that litigation does not accord confidentiality to parties. We are a commercial court, so we are cognizant of business sensitivities. What we will allow for are for applications from parties, for parts of the hearing to be heard in camera, for records to be sealed, for documents, statements, and even judgments to be redacted, and to extreme, where you can prove it necessary, party name substitution. So your court records and your judgments will just state ABC versus XYZ, as an example. So the key thing is, prove to court why you require it. What you don't want is a competitor sitting in a public gallery taking down notes as they are describing manufacturing processes or pricing mechanisms, right? The threshold is much lower, I show you, than within the High Court itself for that. Joiners, this is the other advantage of the SICC. There's no consent required to join additional parties, unlike in arbitration again. And when you join a party, that party does not need to prove that the claim is international and commercial in nature. Okay, and there's no need for written jurisdiction agreement except for states or sovereigns of states. Other than that, there's no requirement for written jurisdiction agreement to join parties into a matter. And if you think further, most times it is not so much that a party refuses to be joined, but there's one of the originating parties that refuses to allow joiners. But here the court will hear any objections, but they will issue an order of court for joinder if the court feels it's necessary. Can I just check? Okay, this is the last one. What the SICC has been hearing recently are applications for setting aside of arbitral awards that's been happening. So the SICC now functions as a supervisory court for IAA matters. Your three advantages that I always talk about by coming to SICC, one is that parties can benefit from our expertise amongst our institutional judges, and many of our IJs actually are established arbitrators, so they know what's right. The two other benefits is, one is in terms of cost. Our cost awards are not taxed, unlike in the High Court. Within the High Court, half-day hearing maximum is about 50,000 Sing. Seldom would you get a 50,000 Sing. Within the SICC, it's on a reasonable cost basis. The other one is speed of proceedings, of which, because we are a commercial court, we do not hear as many matters, so setting aside applications will move across faster. The case I quoted down there was a 6-week interval from filing to judgment being handed down. And with that, I'm sorry, I took a bit of time more. Victor, I'll hand it back to you.
Yes, thank you very much, Lawrence. Thank you. I'll now hand the time over to Nish, who will discuss some of the recent highlights in the SICC.
Sure. Thank you, Victor. Good evening, everyone. I've been asked to give a practitioner's perspective. I assure you, Lawrence hasn't sort of twisted my arm to say anything or not say anything. So this is going to be sort of my view of how the SICC is trending. We are often, as a firm, as Clifford, we are often asked by clients to advise on suitable dispute resolution centers, clauses, etc., for the transactions that they enter into. And we get involved both at the front end of it and at the back end of it when a dispute does arise. Now, SICC is nearly 8 years old, just shy of 8 years old. And I remember when it was first set up, I personally thought it was revolutionary, right? You had a court that had elements of arbitration and arbitration law built into it. It was very different. And as a firm, we recognized that it was a revolutionary development in terms of commercial law. So in the discussions that we had with clients who asked us to say to them, what did we think? How did we think this was operating? We were quite optimistic about the role that the SICC would play within the commercial dispute resolution landscape. So we'd typically go to a meeting room, sit with the client's general counsel. Often, general counsel from the region and elsewhere would dial in, and we would have a discussion. Now, version 1.0, if I can call it that, of the SICC rules, we thought were revolutionary. Now, obviously, Lawrence has gone through some of the recent changes, etc., and further improvements have been made. In terms of why we thought it was revolutionary, the big thing at the time was how litigation could have been done faster. One of the issues we had for commercial matters was we could do, say, $500 million, $1 billion arbitration in 5 days. Often, most sophisticated tribunals wouldn't give you more time than that. Whereas even a $100 million piece of litigation would sometimes take weeks and weeks and weeks because of the evidentiary requirements often that one needed to contend with, right? And the overall process was, in our view, a lot longer than your typical arbitration process. Again, I'm not here sort of to compare arbitration versus litigation, but certainly it showed that there was another way of conducting litigation. And from that perspective, we thought it was a welcome move. Now, between it being a welcome move and clients actually adopting it, there's often a gulf. And one of the things that the clients that we spoke to at the time, and for a period thereafter, highlighted was the fact that although the rules themselves looked interesting, you also had international judges, and conceptually it looked very interesting. They were not in a position to recommend to their board of directors that they should move towards introducing SICC clauses into their contracts because it lacked jurisprudence. So not only did the rules need to be there, they needed to see how the rules were applied before they could legitimately go to their stakeholders and say, this was a court that we could rely on. Whereas the Singapore court, for example, was, is one that they're familiar with, they've seen the jurisprudence, they know what all of that looks like, and therefore, if they were to decide between the two, they would go with the one that has more jurisprudence. Now, 8 years down the line, it is a different conversation today, right? Quite apart from the changes that have been made to the rules to improve the rules and improve the way that SICC operates, we now have a rich body of case law that one can look at, and you can see how the rules are applied and by whom these cases and these judgments are being issued. So not merely the excellent judges that we have locally that would be part of the local litigation scene, but also international judges with background in both common law and civil law and in subject matter, and who have subject matter expertise that could have an influence in how matters determined. So in the few minutes that I do have, I was going to just touch on a few cases. Now, obviously, these cases aren't the only cases that are the SICC has determined, but I just thought I'd highlight a few to give you a flavor of how SICC jurisprudence has developed. And through these cases, I just want to show you some of the features that we as a firm and its advisors to commercial entities, we find both interesting and useful when it comes to commercial dispute resolution. Okay, so I want to start with CKG and CKH. Now, those of you in the sort of commercial dispute resolution world, especially in the arbitration world, will be quite used to the alphabet soup that comes out of confidentiality. Lots of ABCs and DEFs in case names. So it just first illustrates that that is now a possibility in the SICC as well, confidentiality, right? Now, this case itself was one where an arbitral tribunal missed a point that was made by the applicant. Now, I don't want to dwell on the facts themselves. I want to focus on why this case would be relevant from an SICC perspective. Now, an award was issued, and the applicant went to the SICC to set aside the tribunal's decision. Now, the court heard the matter on the 8th of June, 2021, and issued its decision 10 days later. 10 days later, right? So the point that I want to illustrate here is, as a matter of jurisprudence, we have a live example of how quick a resolution of a set-aside application can be made within the SICC. So for us as practitioners, that's important because it's important to our clients, and we're able to illustrate that with a live example. Now, the second takeaway from this case is the fact that the appeals that resulted from the case were also determined very, very quickly, within a matter of months, and without the need for an oral hearing. They were determined on the papers, and again, it's an indication of what's possible within the SICC environment. In both cases, the appellate decisions were authored by Lord Mance, and I believe the first, and I'll come back to this in a bit, but the first instance decision was made by Justice Cook. The second decision that I want to highlight is Kiri Industries versus Sender litigation. Now, again, I'll move through this very quickly. Now, this is Singapore's largest and longest running minority oppression suit to date. Now, although longest running is not exactly the part that I want to focus on, it is the largest. And if you look at the time taken versus the number of decisions in that case itself, then you get to appreciate how large the matter is, but also how complex that matter is, right? So you're talking about 10 reported decisions, 7 in the SICC and 3 in the Court of Appeal. The claim is described as monumental. The liability tranche comprised 79 volumes of documents, valuation tranche 120 volumes of documents. Now, again, to Lawrence's point about trying to save paper, I mean, we lawyers are sometimes constrained, although we want to do it, we are constrained by the arguments that one needs to run. So that is part of, unfortunately, the overall process. But indeed. So the point, the real takeaway here is what the SICC is able to do in terms of management of complex disputes, right? Within a relatively, in the legal world, a relatively short period of time, these many decisions and these many pronouncements have been made for what is a very complex dispute. It has also added to the jurisprudence of Singapore as a whole, even beyond the SICC's own jurisprudence. It has tackled novel issues of law, one of which is the discount for lack of marketability in a very specific, in the context of minority oppression. But again, from an SICC perspective, it shows what is possible. And you can look at the judgment itself if you want to see more details about the case itself. Moving on now quickly to the next case that I wanted to highlight, which is Esben Finance. Now, again, the principles in this case were around unjust enrichment and restitution, and the interplay of these principles with the Limitation Act. Without sort of getting into the principles of the decision itself, what is important is the ability of the SICC to handle what were novel and complex issues. The novelty of the issue did not sort of prevent the determination within the commercial court. And this judgment itself will no doubt determine how these issues are decided more broadly moving forward, right? Finally, I wanted to touch on CSDS versus Singapore Airlines. Now, the matter involved the termination of a contract for the sale of an aircraft. The contract was governed by English law, right? Justice Jeremy Cook was the presiding judge in the SICC for that matter. Justice Cook, as many of you will know, was previously a High Court judge of the English Commercial Court and was in fact for a period in charge of that English Commercial Court. And I said I would come back to the identity of the judges because it is an important factor that we look at as well as practitioners. Right? For the first case that we dealt with, I mentioned his name as well, the CKH and CKG case. He was the judge at first instance, and Lord Mance authored the Court of Appeal decision in that case. In this particular case, again, Justice Cook was involved, and the fact that English law was involved did not prevent the SICC from making a determination, although it was, in the Singapore context, a foreign law. And that is why having experts like them, like him and others, not just for English law, but many of the laws that would concern commercial contracts, subject matter experts within the list of SICC judges makes decisions like these easier to come to when foreign law is involved. So again, just to highlight in the context of the SICC, why we look at these judgments of this nature and say, these are advantages that our clients can look at when looking at SICC as a dispute resolution forum, and why we think that it is certainly a dispute resolution forum that we would recommend to our clients when a client is considering which dispute resolution forums to put into their own agreement. Now, final point really, and this is unique. We're used to the common law principles, we're used to the common law world. The fact that we have civil law judges also as part of the judiciary, part of the SICC judiciary, means that we're now able to determine within the Singapore context, within SICC, matters that would have a civil law element between those clients and those entities and those litigants that have a civil law background, without the need for, let's just say, further expert assistance, perhaps, on how it will be conducted with the benefit of judges that are schooled in civil law principles. I know that I've gone slightly over my time. Apologies for that. Again, I hand it back to Victor.
Thanks very much, Nisha, for highlighting some of the recent SICC cases. I'm now just going to very briefly touch on legislation relating to third-party funding. That's just going to come up on the screen very shortly, and then I'll pass the time after that to Darkis and Ben, who will talk about practical applications of third-party funding. But yeah, so now on the screen, just pulling it up. Yes. Right. Okay. So this is the relevant legislation for third-party funding. Some of you may know that in 2017, the Civil Law Act was amended. The torts of maintenance and champathy were abolished. And basically, Parliament allowed for third-party funding to be used in prescribed dispute resolution proceedings. In 2017, the list is what you see on the screen. It was a fairly small list. It was confined to international arbitration proceedings, court proceedings that arise out of or are connected with those international arbitration proceedings, mediation proceedings also connected with international arbitration proceedings, etc. So all touching on arbitration. That's now been amended with the fact now there will be more categories of proceedings for which third-party funding is permitted. And the one that's relevant for today's event, I think, is C, subletter C that you see on the screen there. Third-party funding is now allowed for proceedings commenced in the SICC for as long as those proceedings remain in the SICC. So this is now one of the prescribed dispute resolution proceedings for which third-party funding is permitted. But that's not to say then that the prescribed categories in the regulations are exhaustive. There's actually case law on this point. In 2019, the High Court ruled that actually the categories prescribed in the regulations are not necessarily exhaustive. But then there's a question then whether you would want to apply to the courts on a case-by-case basis for a declaration that your particular claim is one of those for which third-party funding should be permitted. So there's a bit of risk there. Quite apart from the civil law third-party funding regulations, the SICC rules, one of the innovations, the SICC rules 2021 is that the SICC can now hear cross-border insolvency cases, so long as they are commercial and international in nature. And these are terms that are actually terms of art in the rules of court, so you can look for the definitions in the SICC rules. But the relevance of this really is that the IRDA, which is the insolvency legislation in Singapore, also permits third-party funding in certain cases. So in a way, it's a parallel or a separate kind of jurisdiction, which allows for third-party funding to be used for prescribed categories of claims. There is a certain procedure that's applied. It's set out in the Insolvency, Restructuring and Dissolution Assignment of Proceeds of an Action Regulations 2020. That's a bit of a mouthful. But basically, the insolvency practitioner is able to solicit offers for third-party funding for these kinds of actions. Yeah, so this is relevant because even in cases where the case is not commenced in the SICC, it's transferred to the SICC, but it falls within these category of cases, then conceptually, you're able to rely on the other jurisdiction instead of the civil law third-party funding regulations jurisdiction, I think, to seek approval for third-party funding. But it's a different process, and approvals are required depending on the type of action you're pursuing. You may have to seek approvals from the Committee of Creditors, from the court, for example. So that's just an overview of the relevant legislation. And now I will pass the time over to Darkis and Ben, who will give us some practical illustrations of how third-party funding is executed.
Thank you very much, Victor. Well, it's a great pleasure for Ben and I to be on this panel, albeit virtually. I wish we were there with you in Singapore. It's morning here in France, where I am, and in England, and we're very flattered that so many of you have decided to spend your evening with us on a Friday. The two areas that I want to talk about before I hand over to Ben are really the most fundamental questions of all, which are what's in it for the client with third-party litigation funding, and also, given the themes of this particular session generally, what's in it for the jurisdiction? Why does the SICC as a new trailblazing court want to encourage the use of litigation funding? Now, in relation to the question, what's in it for the client? Traditionally, litigation funding has been seen as something which is for the impecunious. It has its origins, interestingly, in the evolution of the Singapore legislation that we were looking at. It's interesting that insolvency was one of the first areas where it was introduced. But we're now in a completely different world, and particularly in England, and I imagine also soon in Singapore as well, because it's now much more developed as a financial product, a proper financial product, which should be used by anybody. In fact, anyone who wants to de-risk litigation on the claimant side should consider the use of litigation funding, even if they're one of the richest organizations in the world. Why? Because it removes from your balance sheet the provision for working capital, which you would need to make in order to fund what could be a very heavy piece of litigation, particularly if we're talking about cases which are worth over $1 billion, which could consume $10 million or plus dollars worth of legal fees in order to bring the matter to trial. So, how does it work for the client in that situation? Firstly, what happens is that the litigation funder takes on itself 100% usually of the risks of the claimant's own costs. So if the action is a failure, then the claimant doesn't have to pay any costs at all towards the pursuit of the action. Secondly, usually the litigation funder will assist in the obtaining for the claimant of insurance to cover adverse costs orders in the litigation. So there may be some minor capital outlay in the grand scheme of things in relation to that. And what the claimant then does is essentially agree to divide the spoils of the litigation if it's successful at the end of the day with the funder, sometimes by way of a multiple of the fees that the funder has had to cover, and sometimes by way of a percentage of the winnings at the end of the day. Now, this de-risking of litigation for claimants means, as I say, that it is not something which should just be used by the impecunious. It is something which should be used by anybody who is commercially minded in relation to how they want to run their business. In fact, as it was said by one of our co-founders, Edward Grundy, once to me, it's a way of turning a general counsel's litigation, the litigation side of a general counsel's office in a large organization, into a profit-only center rather than a cost center. And I think that's a very good way to think about it, because businesses want to spend money on other things other than litigation. And that business which they have, that litigation which they have on the claimant side is something which need not drain their resources. Now, in relation to the mechanics of it, it's important to bear in mind for the local lawyers who use the SICC, the litigation funders do not control the litigation. In fact, in England still, where there are some residual principles still at large in relation to maintenance and champity, it is an absolute no-no to control the litigation. They do not give legal advice. So the local lawyers on the record in Singapore will retain control of the litigation and retain professional responsibility for the advice that's being given to the client. But there will be comfort to the client in knowing that an independent financier who has duties to its investors with legal expertise internally has also taken the same view as the client's lawyers that an action on the claimant side is meritorious. So that is an additional. It can serve as an implicit cross-check to the client that they are that their lawyers are correct when they're being told that they have a good case. And on the flip side, sometimes litigation funding and the presence of it can encourage parties to settle, because and this is the point I'm going to come on to more fully in a moment, it disincentivizes the cynical defendant who is richer than the claimant to try to outspend the claimant in the litigation and bog the litigation down and to point us into locatory applications and delaying tactics and the like, because that sort of thing just doesn't work when the claimant is funded by a sizable litigation funder. So in relation to the benefit, and this goes on to my second point, really, or my second thematic point, which is the benefits to the jurisdiction. Why is it a thing for the SICC to encourage the use of litigation funding, or at least not to discourage it? I mean, obviously, it's not really the role of the court to be telling clients how to fund their cases, but certainly it shouldn't be something which is discouraged. Now, of course, you've got the cliche, and it's not just a cliche, it's also a truth, that the creation of a fluid and robust litigation funding market does create access to justice for the impecunious. But I think it goes slightly beyond that. It's not just that it aids access to justice for the impecunious, it's how it does it, because it enables it by creating equality of arms in what would otherwise be David and Goliath litigation in those cases where you have a party who is less wealthy than the other. I was very interested to hear what was being said before by both Nish and Lawrence about jurisprudence, because that can only aid the creation of a world-class body of jurisprudence. Of course, you need the quality judges about whom you've been speaking, but you also need parties who've got the resources to administer cases properly and fight them properly in an efficient and proper way. And if you've got one party that is much less wealthy than the other, then you have an imbalance and cases get derailed and things don't happen properly. And so you get a quality of arms and everyone could just focus on what the right result of the case is. And then that creates a disincentive to some of the more cynical tactics one sees in litigation, occasionally from defendants, where they think, the other side don't have the resources that we do, let's just bog them down, which is always an unpleasant thing to see. And a liquid litigation funding market, which is competitive, will minimize the risk of that. And that will only be good for the already impressive reputation of the SICC. So those are the benefits to the jurisdiction, and I've already spoken about the benefits to the client. And because I'm conscious that we don't have a vast amount of time, I want to pass over now to Ben Mays from Hereford, who's going to talk about some of the other factors which we've been invited to discuss. Thank you.
Thanks, Dakis. And could I echo Dakis's remarks and say what a pleasure and privilege it is to be able to talk to you all today. Thank you for having us remotely. I'm going to try in the relatively short time available to cover 5 points. Control of the litigation, which Dakis has already touched on, pricing of funding, how you should go about choosing a funder, CFAs, and then touching very briefly again on ATE insurance. So Dakis has already mentioned control, but I think it's worth repeating his remarks and amplifying them a little bit, because one of the common misconceptions that we frequently hear as funders is, well, I'm giving away control of my litigation here. I'm essentially selling you the claim, putting it in your hands. I'm a general counsel or a lawyer or a CEO. I can't give up control of my own claim. I've got to be able to run that how I please. And as Dakis has said, in most jurisdictions, that's simply not allowed. Either because the rules of champity and maintenance, which I won't bore you with now, are still alive, or because the vestiges of those rules have been imported into the common law or the legislation, such that it's just not allowed for litigation funders to control litigation. There's also a more practical reason why we as a funder don't want to try and control your litigation. It's not our job. We are not litigation lawyers. We may all have been in previous lives, or in Dakis's case, in his with his other hat on. But we are now funders of litigation, not litigators ourselves. The value that we add is by providing the funding and doing that in a way that enables you to get on with your jobs as being GCs, lawyers, and running your own litigation. And what we look to invest in as litigation funders is, as much as the case itself, is the team that is running it, because a great case with a hopeless team is not a fundable proposition for us. So what we want to do is identify good teams of clients, lawyers like Nish and Victor, and allow you to get on with your jobs of running the claim. Coming on to my second point about pricing, and I think this is worth mentioning, one, for the perspective of transparency, and two, because I think it's an area where there can also be some misunderstanding and confusion, particularly for those who might not have come across litigation funding before. There is a perception that litigation funding is expensive, and bluntly, it is, in the sense that litigation funding is not a loan. You do not have to repay litigation funding, whatever happens. Dakis has already made this point, but if we invest in your claim and you lose the claim, you do not have to pay us anything back. So it is not like a loan product or a credit product. It's much more akin to an equity product, and the pricing reflects that. So typically litigation funding, and this is common across litigation funders, will be priced on the basis of either a multiple of the capital that the litigation funder deploys, and that multiple will typically be stepped up over time as you get towards trial. So in the happy event that you settle your claim within 6 months of taking out the funding, the multiple will be that much lower. If it goes all the way through to trial and enforcement, it will typically step up. Alternatively, pricing might be done on the basis of a percentage of the recoveries that you make, or it might be a mixture or combination of the two. As I say, that may seem expensive because at the outset you might think, oh, I'm giving away a lot here. But as I say, that is only payable out of the recoveries that you make and not otherwise. So you are completely insulated from the downside risk and cost of losing the claim. And for the reasons that Dakis has explained, that's why we think it's such a powerful finance tool, not just for impecunious claimants, but also for businesses that could, in theory, afford to pay for it themselves, but want to protect themselves from that use of working capital. So how do you go about choosing a funder? Well, I think the first thing I'd say is go and talk to Nish and Victor or your lawyers, whoever they are, because they will know the market, or certainly they should do in this day and age. I think candidly, lawyers who don't understand the funding market these days are missing a key element of what they need to be on top of. But all funders are not the same, and I think I'd just make 3 key observations in this respect. One, this is a sophisticated product. So you want somebody who understands their own product, of course, but also who understands your business, who understands the litigation risk that you're facing, and most importantly, probably that can work with you and your lawyers over the course of what might be some challenging times. Litigation is stressful and difficult, and you want a trusted partner who you can get on with during that process. You're also likely to want someone who's familiar with the type of litigation that you're asking for funding for. Not all litigation funders are the same. They all have people staffing them who have different expertise in different areas, and you're likely to want somebody who understands what your particular claim is about. Secondly, I'd say look for a litigation funder who can add value to your litigation. As Takis says, we're not your lawyers, we're not advising you on the claim, but the due diligence process that a good litigation funder will go through in investigating for itself the merits of your claim can be a very helpful process for you and your lawyers. And in many cases, our experience has been that our due diligence process and the questions and observations that we make has helped the lawyers and the claimants refine their case just by looking at it from a different angle and bringing our own skills and experience to bear on asking those sorts of questions. I think the third point I'd make about choosing a funder is, and it sounds obvious, but you want to make sure, and you must make sure, that the money is there and that it's ring-fenced for your case. There are some funders, I'm sorry to say, who will only draw down from their co-investors or their sources of funding when the money actually needs to be paid, or even worse, who may have multiple calls on the same pot and be essentially crossing their fingers that those don't all get called at once. So you should look for a funder that will ring fence the money from the outset, that can explain to you what the source of their funding is so that you can satisfy yourself that that money is there. You should be asking DD questions, due diligence questions of your funder, just as your funder will be asking due diligence questions of you. And you should expect transparency and clarity from any funder that you deal with. Moving on then briefly to CFAs, conditional fee agreements, and these tend to be a key part of many funded litigation arrangements these days. I won't go into the Singapore law issues relating to CFAs, not least because that's much more the domain of those sitting in front of you in the room there. But CFAs are now in certain circumstances permitted in Singapore. What is a CFA, a conditional fee agreement? Put simply, it's an agreement between lawyers and their clients which provides for the whole or part of the lawyer's fees and costs to be payable only in the specified circumstances set out in the CFA. And those can be defined to include a range of foreseeable outcomes, such as where the client is successful in its claims or defence, or where certain other agreed outcomes are achieved. And that might include early settlement of the case. Typically, a CFA will provide for the payment of a success fee or uplift on the lawyer's typical fees, namely a higher fee payable if the lawyer achieves the specified circumstances set out in the CFA. And just to give you an illustration of the typical structure of a CFA, you might have your lawyers who would ordinarily charge you 100% of their time costs or whatever the fixed fee might be, but on a CFA they would reduce that to, say, 75%. So you're paying 75% or as you're going along, or your funder is paying for 75% as you go along. The remaining 25% would then be payable only on the success case, plus an uplift, which might typically be another 100% of that 25%. It's very important to contrast these conditional fee agreements with contingency fee agreements, confusingly the same acronym. Contingency fee agreements, which, and please correct me if I'm wrong, remain prohibited or are not currently permissible in Singapore, are fee arrangements whereby the lawyers take a percentage of the recovery by way of success fee. So a conditional fee agreement is an uplift on the standard fee rates a contingency fee agreement is the lawyer taking a share of the recovery, and the latter is not currently permissible in Singapore. It is permissible in many other jurisdictions, so I think in theory it ought to be possible if one was enforcing an SICC judgment in a jurisdiction where a contingency fee arrangement was permissible, to pursue it on that arrangement. So what's the value to you as a claimant of a CFA? I think really there are two key positives for you of a CFA. The most obvious one is that you're paying less. You pay less upfront, and the balance is only payable if and when you are successful, and therefore comes out of your recoveries. I think another slightly subtler positive aspect of it for you is that it makes your lawyers more closely aligned with the successful outcome of your case than it would be if they were just being paid 100% as they went along. Now, you might say, well, why do I care if the lawyers are on a CFA if my claim is being funded by Hereford or another litigation funder? It doesn't make any difference to me, does it? Well, I think the answer is that it does for two reasons. And one, and this is slightly against the funder's interest, the conditional element of the CFA is generally cheaper money for you, cheaper funding, as it were, than having the funder pay 100% of the lawyer's costs. And the reason for that is that, as I've explained, the funder's return is generally going to be either a multiple of the monies that they're advancing or a percentage of the recoveries, whereas the uplift on the CFA will typically be, as I say, 100% of the 25% reduction. And that will typically be a cheaper way to get that part of the lawyer's fees funded than having it funded 100% by the funder and then paying a multiple on that. So it cheapens, it reduces the cost of the overall package for you as the claimant. And also it aligns everybody's interest to have the lawyer, including the funders, to have everybody, the funder, the lawyers, and the claimants having essentially some skin on the game and funders will typically want to see lawyers who can take some risk, taking a bit of risk on a claim that they're funding. If we're looking at a claim with a firm of lawyers that can operate on a CFA arrangement, and they say, well, we normally would, but we won't on this one, that might cause us to ask a question. I think that's probably run through the time allotted to me. I won't spend any more time now on ATE. Perhaps we can cover that in questions if people want to discuss that.
Yep, thank you very much, Ben. We're now coming to the end of today's event, but Lawrence is now going to talk to us about enforcement of SICC judgments.
Thanks, Victor. Okay. The interesting notion that I always find when I engage various groups is that the statement is, oh, it's easy to enforce an arbitral award, but how do you enforce a court judgment? And that's where I sort of smile and actually say that if you really think about it, you look at the origins of the New York Convention. The New York Convention came about because courts were not recognizing and enforcing arbitral awards. Pre-New York Convention, there was something called the Geneva Convention, and there were very few courts that actually recognized and enforced it. Whereas courts had no issues recognizing and enforcing money judgments from other foreign courts, right? Until 1959, they signed it, and it started with, I think, 5 signatories, even much less than the Singapore Convention on Mediation when it was first launched. And only time that now you have 170 jurisdictions that have actually ratified it. So nonetheless, if you look at the screen, I basically have 4 major pillars. From the left is enforcement pursuant to bilateral agreements. Singapore has bilateral arrangements with 10 different jurisdictions. From the South Pacific, you have Australia, New Zealand, Papua New Guinea. You come across to Southeast Asia, you have Malaysia and Brunei. Up north, you have Hong Kong, SAR. You go to South Asia, you have India, Pakistan, Sri Lanka, United Kingdom. And again, unless Nish can actually tell me, for historical reasons, the Windward Islands in the Eastern Caribbean. I don't know why we have a bilateral arrangement with them, but nonetheless, it's there. Attorney General's chambers reminds me that yes, they're still there. So with this, a money judgment from the SICC to any of these 10 jurisdictions, you need to go to a court in Sydney, for example, and have it registered and have the power of a local judgment there. And again, if you're familiar with common law, there are only 4 defenses to such a registration. Number 1, did the SICC have competent jurisdiction? Number 2, was there fraud involved in arriving at a judgment? Number 3, was the judgment debtor accorded natural justice or due process? And number 4, is it against the public policy of Australia? If none of those defenses hold, it will be registered in the Sydney court, for example, and have the power of enforcement. The middle pillar is the Hague Convention on Trust Support Agreements. This is something that came into force in 2015. The 27 EU countries, Mexico, Montenegro, United Kingdom, and Singapore have ratified it. The US and China, unfortunately, have signed it but not ratified it. Where the US is concerned, they still can't decide whether it's ratified on a state level or on a federal level. With the Chinese, it's always a question of when and not if. Nonetheless, we have no issues with enforcement in the US, except for the small state of Louisiana that doesn't follow a common law principle. But I'll deal with civil procedure codes later. And in China, we have had many examples of the Chinese courts actually recognizing Singapore High Court judgments on that. So the center one, the Hague Convention, if you signify that the SICC is a court of choice, choice of court, I'm sorry, then plaintiff goes to a court in Germany to try to file a matter. The German court will basically tell the plaintiff down there, please go back to SICC because you've agreed on that. And subsequently, any money judgments arising out of it, that German court will recognize and enforce. On the right-hand side is what I've talked about traditionally and for decades has always been happening, enforcement by summary proceedings, where you take action on judgment debt. The court will not look at the merits of that judgment, but look at the judgment itself as a debt and recognize and enforce it. Common law countries, I mentioned it. In civil law countries, it's the principle of reciprocity or comity, we talk about it. In essence, if I were to recognize and enforce a judgment from your court, will you recognize and enforce a judgment from my court, right? I have interesting examples on that. In Japan, the Tokyo District Court back in 2006 actually recognized and enforced a money judgment of the Singapore High Court. And the Japanese judge looked at it and went on the basis of mutual guarantee. So what he basically meant was what I said. And his thinking was, if a money judgment from my court now were to go to Singapore, would Singapore court and recognize and enforce it? And his point was because we're a common law court, there were the 4 common court defenses. So on that basis, he said he's going to recognize a Singapore money judgment. There were no priors to that. And on that basis, you could say it's a principle of de jure reciprocity. Okay. Whereas in the Chinese courts, back in 2016, we had one of the Chinese courts recognizing and enforcing a money judgment of Singapore court because 2 years before that, the Singapore High Court actually recognized and enforced a money judgment from a Chinese court. So the judge on that went on the basis of de facto reciprocity. Okay, and just a quick aside out of it, there's issues between the Chinese and Japanese courts right now because I think the Osaka High Court started by not recognizing a Chinese judgment. Then the Japanese judgment went to China and didn't happen. And it was not recognized and enforced because of what Osaka Court did. And therein, so the privileged position in SICC is that if you have Chinese and Japanese clients or parties, it doesn't matter, come to the SICC. Either side, whoever wins, you can get it enforced in either jurisdictions because it's a Singapore money judgment, right? Unless you want to go on the narrow part about public policy, then I'll leave that side of it. So you have that aspect of it. And the last example on the civil law jurisdiction I'll give is actually Vietnam, because a lot of people actually say that no, the Vietnamese courts don't recognize foreign judgments, but we've had a Singapore money judgment actually recognized and enforced in the first instance court of Ho Chi Minh City. And it was even upheld by the Court of Appeal of Ho Chi Minh City on that. So just a very quick one, that's where we are in terms of recognition enforcement. Okay. And for those who want to do further research, there's an organization called the Standing International Forum of Commercial Courts. And those are all the commercial courts from around the world that have actually signed a multilateral memorandum of guidance on the recognition and enforcement of money judgments. It's non-binding, but the fact is that each of those courts there who are prepared to state that these are documents required and these are the procedures required for having a money judgment recognized and enforced in my courts actually lend lots of confidence to parties when dealing with the various jurisdictions over there. So that one, I want to hand back over to Dakis and Ben to talk about why litigation funders are actually quite confident with funding matters before the SICC or other international commercial courts. Dakis?
Yes, thank you very much, Nick. Lawrence. This is a very important point for us. It is, in fact, on the checklist for every case that we fund. In fact, we almost start with enforcement before we look at anything else. So we say, right, is the judgment at the end of the day going to be one which is going to result in some recovery? And if the answer to that question is no, then it's game over, irrespective of the merits of the case. So that sort of intelligence that we've just been shown on those slides is of the utmost importance to encouraging funders to fund cases in the SICC. But there's another point in relation to this, which may be interesting to you, and that is that funders are often brought in at the enforcement stage. So claimants will get their judgments, realize that there is an enforcement difficulty, and then the probability analysis or the factorial analysis changes for the funder, because you're looking at the prospect of success in relation to the prospect of enforcement. So you're not starting at the beginning and saying, are we going to be able to enforce it at the end of the day? The thing that you're investing in is the enforcement of the judgment. And it will give tremendous confidence to funders investing in your jurisdiction, that you're able to look at those three pillars and see just how well respected the decisions of the Singapore courts are. I mean, certainly in the common law world, I can't imagine anywhere that wouldn't, unless there was an issue about non-submission to the jurisdiction or public policy, that wouldn't enforce a Singapore judgment, or unless you're in one of those very strange Caribbean jurisdictions which have anti-enforcement legislation when you're interfering with certain local structures that they have. Just to give you a practical example, I was as counsel involved in a case for a very long time, which was all about the enforcement of judgment, which was funded by litigation funders who hadn't funded at the substantive stage of the proceedings. The client had funded up to the judgment, and then the funders came in to fund what was basically a new phase of global commercial litigation as the judgment was taken around all of the jurisdictions in the world with a view to enforcing it. It was an English judgment, and not all of the jurisdictions would enforce an English judgment, sadly, but eventually there was a settlement, and the funders and the client were all paid out. Ben, do you have anything to add to this particular topic?
Well, I think I would just endorse what Lawrence has said, which is that I don't think you should be afraid of enforcement going into litigation. Firstly, most judgment debtors pay up. It's not every case that you've got to chase everybody around the world. Secondly, if you are unfortunate enough to have a judgment debtor that doesn't pay up, the world is now a very connected place, and through the mixture of treaties, reciprocity, common law, and so on that Lawrence has set out, there are very few places where you cannot now take a judgment or an award and get it enforced quite readily. The structures are there, the courts are there, and are generally minded to be of assistance. The local professionals will understand the way to do that. I mean, my personal experience was in the offshore jurisdictions, BVI and Cayman, particularly where I used to work, where that was a huge part of our diet, enforcing those sorts of awards, and it's a very sophisticated setup. And the last 10, 15, 20 years, I think has seen a huge increase in the range of tools and skills and professionals available around the world, not just lawyers, but also asset recovery professionals, insolvency practitioners, and so on, who can help with enforcement. So I would say don't be afraid of it. But do think about enforcement at the outset of your litigation. I think perhaps 20 years ago, people will go into litigation thinking about how do I get judgment? Well, that is only stage one. It's no use to you if you don't get paid. So what you really must do is at the outset of your litigation, think with your legal team and wider team, well, how do I actually get the money out at the end of this process? And your entire litigation strategy and funding strategy ought to be informed by how to get paid at the end of it. And that can make a material difference to your litigation strategy. For example, the question of where you start to litigate. And obviously one of the great advantages of the SICC is, as Lawrence has explained, that it is a jurisdiction where enforcement is going to be straightforward in a lot of other places. So you want to be litigating somewhere where you know you can take your judgment and get it enforced elsewhere.
Thank you, Lawrence, Dakis, and Ben, for sharing about enforcement of judgments. We're at a stage of this evening now where it's basically Q&A time. If anyone here attending physically has questions, the mic is available there. So if you do have questions, please come up, just introduce yourself, and you can direct your questions to any of the speakers here. To those who are attending virtually, you're able to type your question in the chat function. I have access to that, and I'll read your question out for the benefit of everyone here. Yeah. I suppose while everyone is considering what questions they might want to ask, I think it's my role as the moderator to ask the first question. Perhaps Dakis and Ben, I think you spoke extensively about funders funding the claimants. Do funders fund the defendants in disputes?
Ben, do you want me to go first on that one? So the answer to that is very rarely, but it's not impossible. There's one obvious way in which it's possible for a defendant to be funded, and that's where you have a fiduciary claimant who is asking for directions as to who owns the particular fund, and then joins all of the potential claimants to that fund. And in that sense, theoretically, defendants are in fact claimants. So that's an obvious way in which you could fund a claimant, a liquidator or a trustee or someone like that being the claimant, but the potential claimants to the fund being the defendants. But actually, I can think of a way, I personally haven't seen it, but I can think of a way in which a defendant could go to a litigation funder. And that would be in circumstances where you have a pecunious defendant who doesn't want to spend time and money on defending a case and is prepared just to pay a damages claim that's made against it 100 cents in the dollar, but thinks, if a litigation funder and some lawyers can tell me that there is a defense here and are prepared to fund it and take the risk off my table in defending the claim, I will pay the litigation funders a premium if they're able to put me in a position where my liability to the claimant is less than I am today prepared to pay. Now, that situation in a commercial case I could see happening, but it isn't one which one sees very often. I don't know about you, Ben, whether you've seen.
I think historically, defendant litigation funding has been very limited, but I think that's largely because until fairly recently, litigation funding hasn't started to be seen as the sort of mainstream finance tool that Dakis was explaining earlier it ought to now be seen as. And defendant litigation funding is really only going to be possible in broadly two main types of case. One, as Dakis has suggested, where broadly a defendant is defending access to a pot of assets, so may not in fact be able to pay for the defense other than out of the assets once the defendant's control or ownership of those assets is determined. And that's, I think, always the most obvious type of defendant-funded case. But also the other circumstance in which it might more be possible is where a defendant, particularly a corporate financial institution type defendant with a deep pocket, nonetheless doesn't want to pay for the litigation for the reasons Dakis has explained. And historically, I just think that those sorts of defendants just wouldn't have thought about litigation funding and would not have gone to the market, resulting in there not therefore being that sort of defendant funding. So I suspect that as litigation funding becomes a more well-known and widely accepted finance tool generally for corporate defendants, that the use of funding for defences will start to increase.
Yeah, you should do it in those circumstances.
Answer. I have a question from the floor, and the question is more for Dakis and Tibet. The question is, what is the minimum claim amount to attract third-party funding?
Shall I have a go at this, Dakis? Well, I think there are two parts of that question. One is that it will depend on the funder. There are funders operating in all different parts of the market. Some that look to fund lower value cases and some that look only to fund higher value cases. Typically, the larger funders who have institutional backing, and Hereford is one of those, and there are plenty of others whose names you'll be familiar with, will tend to look for larger claims. But there is always somebody at whatever price point you're looking in the market who will take that claim on. The second aspect that comes into play, though, is a funder will always want to see that there is adequate headroom between the amount of funding that is sought and the recoveries that the claim is pursuing, to make sure that the funder can get their money back, that the funder can get their return, and that, importantly, there is some money left over for the claimant, because funding isn't very much used to anybody if the funder ends up scooping the pool. And needless to say, that equation gets more difficult with smaller claims, because, as any lawyer will tell you, a claim with fewer zeros attached to the end of it is not necessarily any less complex and difficult to run than a very large claim. So the problem or can be at the lower end of the market, matching the funded budget to the amount of recoveries available to cover it. So I hope that helps answer that question.
Right, thank you very much for that question. If there are any questions from the floor, if not, perhaps just a question for Lawrence, a question for the SICC. So one of the points that was on the innovations now is that third-party funding is available, but for actions which are commenced in the SICC. And I was wondering if you were able to give us some insight into how many actions are commenced in the SICC as opposed to transfer cases. Yeah.
Given that the regulations are quite new, unfortunately, there are no matters before the SICC involving funding, whether on a direct filing basis or on a transfer basis at this point in time. However, I understand that one of the setting aside applications that we heard was actually funded from the arbitration side. So because of the rules, even when it came for the application before the SICC, it would continue to be funded. So only on that one matter at this point in time.
Right, understood. Okay, thank you very much for that. Yes, we have a question here. I could trouble you to go to the mic.
Hi, I'm Roseanne Rojas. I'm from SMU, a student. So I'm actually from the Philippines, and I'm kind of interested in this. Is actually I'm kind of new to the concept of third-party funding. So the reason why I heard from other arbitrators is that Philippines does not have third-party funding is because of, one of these is lack of cause of action, and also because of ethical reasons. I would just like to ask, how does that reconcile with having that? I mean, how does it solve those supposed problems?
I wonder whether Dakis, you might have a view on this question.
Yes, well, the lack of cause of action and the ethical reasons, I suppose, are two sides of the same coin. Because historically in England, until about the 1960s, it was thought totally wrong that somebody who wasn't a party to litigation should be funding someone else's claim. A fortiori, if they were funding it with a view to personal profit. And that was abolished as a crime and a tort in the 1960s. And over time, the public policy considerations in relation to it have been, in relation to that thinking, have been counterbalanced by concerns about access to justice and about equality of arms and all of the other things that I was talking about as well. So the purity of the law being interfered with by people profiting from cases, concerns, I think have been seen to be less important in relation to the countervailing problems in the modern world, particularly the problem of what we call David and Goliath litigation, where you have the small guy against the big guy, and you need to balance out that inequality. And also, as I say, when you're talking about purely commercial litigation coming purely out of the commercial world, why shouldn't there be the same diversity of financial products available to the market as in relation to funding of litigation, as there are in relation to the financing of any other aspect of commercial life? So I think that the answer to your question, I can't speak for what happens in the Philippines, but in respect of the general global direction of travel in the common law world in this area, litigation funding is here to stay, albeit that there are still some areas where one can, for ethical reasons, one could never see it really coming in. For example, and also practical reasons, litigation about children, litigate and crime and things like that. I couldn't see it happening there. But in relation to commercial work, I think the ethical concerns have been outweighed by the ethical benefits, and I do say they're ethical benefits that litigation funding supplies.
I'm afraid we can't hear the speakers at the moment.
That's why I asked whether it's on. Did you do this? You spoke and it worked? Well, is time up and they can't hear me? Yeah.
Darkis and Ben, are you able
You have
to
to
hear
speak
this?
louder? Or?
We can hear you now.
We can hear you now.
Great. Okay. Just before the bell went, I wondered the part about crime and children. So is there any reason in principle why litigation funding should not be available for actions by corporates or private parties against state entities, public services, governments?
I don't know whether you want to answer this, but states get funded claims made against them a lot. Ben, you can give an example from our own book.
No, quite so. So bilateral investment treaty arbitration, for example, is one of the types of dispute resolution that is probably most funded. It's a very a lot of BIT claims have been funded over the years. We are funding one as we speak in an African jurisdiction. So funding is regularly used against states and governments. Obviously, it will depend on the jurisdiction in question whether that is permissible, and all of the sorts of ethical and control issues that have been identified, that DACIS has identified, and that the Singapore government has worked through in legislating in your jurisdiction will obviously come into play. But I think commercially and as a matter of principle, we see no reason why funding shouldn't be available for those sorts of claims. And as I say, it is in many jurisdictions, if not most.
Any issue with claims against the revenue state tax authority in the home jurisdiction, or by foreign parties against foreign tax authorities?
I'm sorry, the beginning of that question.
Because I practice tax law. So.
I think we just have about enough time for a very quick answer to that. If Dakis or Ben, you have any quick views to offer on this question?
I'm sorry, we missed the beginning of the question.
The question was whether there's any issues with claims being made against the revenue or tax authority, essentially.
I'll let Ben answer this one as well, because he's all over this.
Well, if I can answer it with an anecdote, I am currently involved in funding more than one claim against Her Majesty's Revenue and Customs in England. So that may answer the question in itself.
Right. Thank you very much for that. I think we are now at the end of the today's event. Thank you very much to our online audience for attending virtually, and thank you very much especially to our audience who's here with us today now. Thank you very much to our speakers for the illuminating discussion we've had today. Thank you very much. That's the end of today's event. Thank you.
Thank you.
Thank you, everybody.
Yes, we have a reception prepared at the back. Please feel free to grab a drink. It is Friday night.
Enjoy the drinks. Bye.